SJC-10196, Commonwealth versus Raposo.
Good morning.
Good
again,
morning,
Your
Ms.
Honor.
Eisenberg.
Beth Eisenberg and Colleen
Thank
Tynan
you.
for Mr. Raposo. I don't need to reiterate Ms. Chayton-Pollock's remarks. I want to make 4 quick points about the particularities of Mr. Raposo's case. First, the defendant was to complete his period of pretrial probation on December 26, 2008. And to the best of my knowledge, he has done so. So the issue now is, the question is whether it is capable of repetition and may easily evade review. We maintain that it certainly is. It's been fully briefed to this court, and so we ask the court to please reach the merits of the questions that have been presented. The second is the question of the defendant's consent. The government has argued that since the defendant's consent is a prerequisite to pretrial probation, the question of fairness or legislative intent isn't relevant, because if the defendant didn't want to be subjected to GPS monitoring as a mandatory condition of pretrial probation, he can just opt out and insist on his rights to trial, and they call that a package deal in their brief of mandatory monitoring and pretrial probation, and they say that is all the process that's constitutionally due. And we see the problem with that analysis as threefold. Number one, it begs the question, which is whether 265-47 was intended to apply to pretrial probationers. Number two, putting aside consent for the moment, the government's position doesn't really answer the question of why an individualized determination of the need for GPS monitoring is unnecessary. If it's unnecessary, then it's punishment. And if it's punishment, then it doesn't apply to pretrial probationers. And the third problem we see is that the government's analysis confuses the defendant's freedom of opting out of pretrial probation with the actual process that's due in examining the constitutional freedoms at stake here that Ms. Chayton-Pollock and Ms. Eisenhower talked about, which includes fundamental right to be free from physical restraint unless the government can demonstrate a compelling reason with a narrowly tailored proposition. And the prosecutor doesn't really say anything about those needs. The second point I want to make is that under Section 47, the mandate that the probation department, rather than the judge, determines the exclusion zone violates the law that's been established in Massachusetts, certainly by common law in this court's McDonald case and the appeals court's Lally case. The government's argument that the probation department's determination of exclusion zones affords the probationer the kind of individualized determination that due process demands is not the kind of hearing that due process demands, because it leaves open whether the underlying monitoring condition is rebuttable, and we say that it's not under the plain language of the statute, and the determination of the exclusion zones that goes with that is really, as this scheme is set up presently, a purely an administrative adjunct of that monitoring system. The third point that I want to make is to clarify the equal protection claim here. We don't say that individuals accused of sex offenses can't rationally ever be subjected to GPS monitoring as a condition of pretrial probation. They can if it's individualized. What we say is that because the specific mandatory conditions here infringe on fundamental liberty rights, and under the law, doing that requires this compelling reason analysis, it's unconstitutional to treat pretrial probationers merely charged with sex offenses differently in this way from all other pretrial probationers, where those distinctions in treatment of them is not soundly rooted in fact. And the last point that we'd like to make is with respect to the retroactive application of Section 47 to Mr. Raposo, because his alleged crime occurred before the effective date of the statute. Now, if the legislature intended Section 47 to be punitive, or if this court determines that its effects are sufficiently punitive regardless of the legislature's intent, then the question of whether Article 26's proscriptions of cruel or unusual punishment that the government briefed don't need to be reached here because a punitive statute would not apply.
Well, are you arguing that it's just the physical placing of the device on the body? Because the individual could be required to call up probation every hour and make a phone call, and that's certainly disruptive, and they would have to leave wherever they are, and you don't get cell phone service, and there are all sorts of problems. So what are you, and it's just a monitoring of where the individual is. It's not an additional condition, or that's an argument. So are you saying that it's just the simple wearing of the device that is the problem?
It is. It is the way in which the monitoring is effectuated that interferes with the rights that we've asserted this morning.
So is it, this is something made, an argument, I think, in the parole case, but is that, do you call that an as-applied attack? In other words, in the way that it is being effectuated? If, as somebody said, you had an invisible
Chip.
chip, or, and let's say you didn't have to insert it in the body. I mean, but it was essentially invisible, and somehow the phone was a lot less, didn't have GPS and orange letters on it, and you could do whatever, and it worked well, and it didn't go ringing off all the time. Would that be a problem? I mean, I'm just trying to get at whether it's the way that it is being implemented, or is it the fact that somebody's watching, that you're being monitored in this way 24/7.
The way that it is being implemented effectuates the legislature's intent, we say, because the language requires it to be worn. And what we say is that because the language of the statute requires the GPS apparatus to be worn, there is a publication of status inherent.
What if
I understand that. I also understood Ms. Chayton Pollock, and I understand you're not arguing for her, but she made a fundamental liberty and privacy argument.
Yes.
And is it your position that if it could be done in a non-public way, to take Justice Islands, that is to say you have an implant, and so the question is, that goes off with a buzz in your hand or something, that you have to report in, that there are no privacy interests in the government knowing exactly where you are in a way that an hour telephone call a day, and I don't know any probation requirements that have ever required an hour telephone call a day, does not implicate a privacy interest, even if people around the probationer did not know.
It
Are you
doesn't
saying-
implicate a privacy interest under a due process analysis. It may under whether it's a reasonable search or a seizure analysis, but it doesn't implicate it under a due process analysis, because those due process analyses, like in Wisconsin versus Constantino, are always about the infringement of privacy in terms of publication and resulting reputational injury. It remains a liberty infringement throughout.
Thank you, Ms. Eisenberg.
Thank you.
Ms. Eisenhower?
May it please the Court, Rachel Eisenhower for the Commonwealth. If the legislature ever intended the statute to apply to pretrial probationers, this is absolutely the situation they did intend it to apply to. This is dispositional pretrial probation. It's like a quaff without a guilty finding, and to that extent, it's the last interaction the court will have with him if all goes well.
In order for this to happen, the consent of the defendant and of the Commonwealth was necessary.
Yes.
The consent to the specific conditions.
Yes, and
that was done, and there was no GPS.
yes, but it was after the effective date of the statute. So our position is that that's an illegal agreement, essentially. I mean, there are other cases in the Commonwealth, I can't think of the names right now, where judges in the district court agreed to quaffs under conditions they shouldn't have, and it's always sent back for reformation. But
The Commonwealth can agree to lots of things, as it turns out, that a judge can't otherwise do. A judge can't, we've said, a judge can't impose pretrial probation as a disposition of a case, unless, of course, the Commonwealth agrees to it.
absolutely, absolutely. But the Commonwealth can't agree to waiving a mandatory statute that had just gone into effect, nor could the judge.
You're
Assuming the
talking about
statute applies to persons who have not pled guilty, admitted to
Assuming
sufficient facts.
that it applies to Section 87, and if you hold that it does not, obviously that solves the whole case. But
So when you talk, excuse, I just want to make sure I follow you. So when you're talking about the mandatory statute, you're talking about 47, which is imposed once you get a supervision under 87.
yes.
Okay.
That's what
And-
I'm saying. The other point I would make is that this is not a restraint. Ms. Eisenberg referenced earlier cases where individuals were shackled to beds. I mean, that causes severe muscular atrophy, things like that. These people are able to walk around, go places, do things. The only places they're not allowed to go are exclusionary zones, which in many cases are
Can they
places...
swim in the sea?
Pardon me?
Can they swim?
they
Go
swim in the
take
sea?
a bath?
I've heard conflicting things,
Okay.
and so I'm
So you
really
don't-
not comfortable answering that question. Some people have told me yes, some people have told me no. So, but in any case, the probationer does, after all, have a limited liberty interest anyway under Pike. So the limited infringement on his right to move around is in accordance with things that we've already held as appropriate under probation. Now, probation is a creature of statute, as you know, and so the legislature is entitled to regulate it as such and to put limits on the judiciary if it wishes. And in this case,
I don't think they're putting limits on the judiciary.
I know it's shocking, Your Honor.
No, I don't think they're putting limits on the judiciary. I think that, you look to see what what we do in every case is look to see what the legislature intended. I don't think one branch puts restraints on the other branch.
Perhaps I phrased it inadequately, but my point is that probation's a creature of statute and
Of
that
course.
the legislature can regulate probation. Now, to the extent that probation is part of the judicial branch, that was all I meant.
Oh, okay. I see what you're saying. I'm sorry.
So
They, of course, can't pass ex post facto laws.
they cannot pass ex post facto laws, but, Your Honor, I believe that this situation has more in common with Bruno than with the 2008 Doe case.
Why?
Because the triggering event is one's current probationary status. It's supposed to be a method for probation to monitor what's actually going on with people who are supposed to be under its supervision.
You're not going to have to explain that again. The triggering event.
Is
It's
Section 87, correct?
The triggering event is the fact that you are under supervision of probation, and probation has a right to monitor you in a way that the legislature has deemed to be the most effective monitoring device in its judgment.
I understand that, but with respect to the ex post facto, you would say if the legislature changes its mind along the way, that does not give rise to an ex post facto situation. That I think is the gist of Justice Cordy's.
That is my argument, Your Honor.
So if you were on...
And can I just ask you, why?
Because the statute has neither punitive intent nor punitive effect, as I discussed in both the Raposo brief and the
Right.
juvenile
No,
brief.
I understand.
Yes.
So would you say that if you had a Section 87 permits what it permits, and the legislature decided they didn't want it anymore, would the Commonwealth, would the probation department then be able to end all those, whatever agreements were out there? for
And return everyone to prison? I
Well,
believe
I
not.
guess they would have to go to trial. Well, they could go to, they could go to prison.
I believe that the legislature could absolutely revoke Section 87 as a dispositional device and return everyone to trial.
You mean
and-
actually revoke all the agreements made under a statute?
Yes, I believe
And
that
send everyone
they
to trial? You think they could do
I
that?
believe that they could. And
Hold them on
of
bail.
course, and the reason that would be fair is because the Commonwealth's ability to prosecute has gone down as time goes by. So they have received some benefit from this agreement. They're now facing a 5-year-old prosecution instead of a 1-year-old. Of course, that's obviously a very uncomfortable scenario. I don't like your hypothetical at all. If the court has no further questions, I am out of time.
Thank you, Ms. Eisenhower.
Thank you.